Good evening, everyone, and welcome to today's webinar hosted by 𝐀𝐧𝐣𝐚 International USA. Our webinar today is an attempt to address a dilemma that may be on many of our minds, especially following the recent executive order in the United States. Today, we'll focus on clarifying the impacts of the executive order on immigration visa status of many people across the US, and in particular, international students who may be concerned with H-1 visas. Now, before we jump into this very important topic, I'd like to take a moment to share a little bit about the organizations coming together today to host the webinar. 𝐀𝐧𝐣𝐚 International is a Hindu faith-based nonprofit whose mission is to serve humanity with a particular focus on disaster recovery, family and child welfare, and promoting volunteerism. We also have Hindu Yuva, a student organization with chapters at 33 universities across the US, with a vision to practice, preserve, promote, and protect Hindu Dharma. Bharatiyam is a pan-US forum working towards bringing together Indian students in the diaspora together, with the aim to provide a nurturing platform for Indian students in the US to motivate them to contribute significantly to the growth of India and the USA. Vivekananda House is a residential Hindu student center on university campuses. It aims to provide a vibrant and positive Hindu experience to the campus community. Unite and Inspire is a nonprofit organization primarily based in the Houston area and across India, promoting volunteerism and active involvement of youth, children, and adults in the service of the community. With 18 other organizations locally and over 150 volunteers, Unite and Inspire is serving the community and making a real impact. And finally, Hindu University of America is a premier institution of higher studies in civilizational knowledge and dharmic studies for initiated and uninitiated, covering a broad spectrum from academic requirements to spiritual growth. Hindu University of America will act as an umbilical cord for current and future generations and connect them to their roots of Hindu Dharma. We're really delighted to bring all these organizations together today, and I'm especially excited to introduce our speaker, 𝐀𝐧𝐣𝐚 𝐁𝐿𝐼. 𝐁𝐿𝐼 Ji is an experienced attorney with over 20 years of experience with a passion and dedication to integrity and results for her clients in business and contract law, business and family immigration, and employment law. 𝐁𝐿𝐼 Ji earned her undergraduate degree at Brandeis University and a JD from Thurgood Marshall School of Law. She meets her clients' goals with expertise, commitment, and perseverance, tackling complex federal and state laws today, while ever ready to help her clients meet their future business and personal needs and goals. We're really excited and grateful to have 𝐁𝐿𝐼 Ji with us today. And thank you so much for sharing your wealth of expertise with us. And I'll hand it over to you to kick off the webinar.
Thank you so very much, Amrita. That was so sweet of you. And I do appreciate this. And I want to thank every single one of the organizations that's involved. This is a true pleasure to do. I know that this has disproportionately affected most of our South Asian community. It is on the minds of every single individual holding a visa currently in the United States, outside of the United States. And I know that it's certainly weighing heavy on attorneys like myself and the clients that we serve. And so it's with great dedication and joy that I'm able to try and provide some guidance, information, and help individuals today. I hope that we will have to be able to do some webinars that are going to be of a more generous nature than these executive orders have been, but we will help everyone get through this together. And so I'm ready to go ahead and start my presentation. So for all of you joining here today, I know that you may be individuals that might be actually having H-1B visas, some form of a dependent visa like an H-4 as well, L-1 visas, and those individuals who are on J visas who know that this impacts them currently, but we're going to go through and explain all of it as best as we can with up-to-the-date literal information that has come down even as of yesterday. So I will be happy to help you with that. So we're going to navigate the proclamation, which is 1001. More there'll be, but here we are. So we want to go and talk about who is affected and determining who, when, and where this is going to impact at this point. So who actually is affected by this? Well, right now, the most important categories are for H-1Bs, H-4s, L-1As, L-1Bs, L-2s, which would be the dependent visas, J-1s with exceptions, and H-2B visas. This current proclamation serves as a suspension of the processing of some of these visas and the ability to enter onto them if you are outside of the United States without a visa. And I want to stress that, and you'll see that from the infographic that's in front of you, that this would disproportionately affect those who are, and it is disproportionately affecting Indian nationals and Chinese nationals and South Asian nationals because they hold the larger portion of these visas. So if you're on an H-1B and you are outside of the US without a visa, what exactly does that mean? It means you do not have a visa that is stamped actually into your passport. What happens if you are inside of the United States? Well, we'll be going through that in a little bit. If you do not have a visa stamp, you cannot enter the United States after the date of the proclamation as of June 24th. If you have a visa stamp that was valid on June 24th or prior, and it is for an H-1B or for an H-4 dependent visa, you are eligible to be able to come in because you do have a visa stamp in your passport. Now, how does this affect L-1As, L-1Bs, and L-2s who are dependents? It is exactly the same situation. The first prong of this particular proclamation deals with the issue of whether or not the individual is inside of the United States or outside of the United States. So again, if you are outside of the United States without a visa stamp, you cannot enter at this point. And this will predominantly affect those who are either on H-1B potential cap cases, and I will go through this as well, that may be outside of the United States, that have been in the most recent 2021 lottery for H-1B. And if they were to get approved and their submission has taken place here stateside, effectively what is happening is that they will either get approved, and if they get approved, they would be allowed under normal circumstances to join and come to the United States by October 1st of any fiscal year, if in fact they have an approved visa. They would be sent to a consulate, they would go ahead and get their visa stamp, and they would enter in on their H-1B and start working. This particular proclamation is aimed at those individuals specifically to be able to try and suspend their entry until December 31st, primarily not for the fact that they won't get a stateside approval, even if they were in the lottery and a case has been submitted on their behalf. The issue now becomes, is the Department of State going to actually stamp a visa? Are they actually going to entertain these visas? And we do know that they have issued information as of yesterday and day before indicating that they're not going to. And the reason why is because of this particular proclamation, which again, I want to go into a little bit of the legalese for it so that people have an understanding of how it disproportionately affects. The idea is that it's not going to affect stateside petitions for change of status or extension of status for H-1B individuals, for their dependents, or for L-1s and their dependents. This is specifically for issues regarding individuals who are outside of the United States, who do not hold this visa status currently in their passports right now. Those are the individuals that need to be looking at this webinar specifically and understanding that it applies to them. So if you have a valid I-797, and for my H-1s, they know this, all of my L-1s, they know it, they live on this understanding of what that form is. It is a form stateside known as a form I-797C that serves as an approval notice that indicates that you are approved for a visa stateside. If you have a corresponding I-94, and everybody who has ever traveled to the United States knows exactly what that is, it's an arrival and departure record. When you are stamped at the port of entry, that indicates your current visa that you may be on here in the United States, and it actually has the date for which your validity is legal all the way through for your visa. If you have those items already, and you are in, let's say, under COVID-19, you had to travel and you were, for lack of better terminology, trapped overseas while you were having to visit family members, perhaps go there for business. If you still have a valid visa, you have a valid I-94, you have a valid I-797, and it was stamped on or before that particular date, ostensibly the idea is that there will be no impact, but we'll talk about that in a few minutes here. So again, if you have valid visa status, it has absolutely no impact. And that goes, again, for H4s with a valid EAD as well. Now, if you're here in the United States, you need to understand that all of those little green underscorings here all apply to you. The idea is that if you're already here in the United States, when you have an I-94, you have your I-797, you are stamped in here, regardless of whether you are going to be extending or whether you might be changing that status, you are currently not affected by this proclamation. And in addition, the same thing goes for our L1s. And again, if they have a valid visa stamp, there is no impact. And that goes for our L2s with valid EADs as well. Now, for J1s, it's very interesting because a lot of people don't pick up on the exceptions that are indicated here. In the proclamation, J1s are suspect and well, we'll use a different terminology. The administration would like to call it suspect. They are actually going to be under this suspension. The problem will be that if they have a valid visa stamp or any status documents, again, there will be no impact. So even in the categories that are listed below that they do apply to, if you have a visa stamp and you have status documents, there would be no impact if you're here in the United States. So again, if you're outside of the United States without a visa, you cannot enter. In other words, if you were an intern, a trainee, a teacher, a camp counselor, an au pair, which are basically within the nanny category, or you were trying to do summer work travel programs. At that point, if you're overseas and you had applied for this and you do not have your visa stamp, maybe because the consulate was closed due to COVID-19 or any other issues that might be there where they delayed a visa interview for you, at that point, you will not be allowed to enter into the United States on that J1. Now, what's interesting about this proclamation is the timing on it, because we know, as a matter of fact, back in March, that the majority of the consulates were closed at some point, and processing had been suspended anyway. So what exactly is this trying to do? Is it actually trying to limit any additional people once a travel situation might be possible for international travel? Yes, it is. And one of the reasons why is, and this is again going back to the legalese, and we'll go into it a little bit more in a couple of other slides, but I do want to make this clear, that the authority of the President of the United States to issue this proclamation is based on a statute that basically deals with entry of non-immigrant visa holders. It is not over anything that takes place here in the United States as an extension of status or a change of status. This specifically goes to a statute that deals with majority of the time national security issues as to whether or not he can suspend non-immigrant visa holders from entering the country. The proclamation has been issued with the intent that it would serve as economic hardship issues to the United States. There is, in most legal minds that have actually parsed through this, and we are parsing through it, the idea is that economic hardship may or may not be, in a court sense, something that would be upheld at some point as a reason to stop H-1B, H-4, L-1, L-1B, L-2, and J-1s from coming into the country. And again, the exceptions for J-1s would be obvious to some extent. They would be physicians, nurses, individuals that would be helping out with the medical crisis and that sort of thing as well. For H-2Bs, if you have a valid I-797 and an I-94, there is no impact to you. If you have a valid visa stamp, there is no impact to you if you are here in the United States. And so this is the bulk and the majority of the very specific and limited categories that they have actually indicated here. Now, does this mean that it won't be expanded? No. Does it mean that it can be expanded? Yes. Right now, I think the focus is on L1s and H1s in the economy in general, and businesses have come out on bank to indicate that this is not a good economic move, and that it disproportionately does not make sense in many ways, primarily because if you look at the numbers for economic hardship, in terms of the unemployment, if you look at the H-1B sector, or you look at the tech sector, or you look at the engineering sector, where the vast majority of our H-1s, our L-1s come from, the level of unemployment is only 3% currently. And so the question now becomes, is this really going to assist with the economy? Is that the actual reason for this? So with that being said, we'll go to the next slide to delve in a little further. So these are the non-immigrant visas that are not affected, because it's very easy after reading this and looking at the news and knowing what we know to feel like everything has been stopped at some point, but it hasn't, and that's a good thing. We have B1 business visas, which some people do not understand the difference between a B1 and a B2. There is a vast difference. A B1 visitor visa, I'm sorry, a B1 business visa is with the intent of having an individual come here to the United States from an overseas company to stay for a period of time, usually 6 months to 1 year, in order to be able to assist a business here in the United States. And it comes with its own regulations, its own requirements, which you would want to check with a competent attorney with, but that is a valid option available. B2 visitor visas, for obvious reasons, everyone knows what those are. That is here to visit the United States, and there's a myriad of reasons to be able to do that. And so if anyone would want to be able to, for family purposes, for emergency purposes, for other medical issues, those are the kind of things you would want to go to a lawyer and discuss. It is not advisable to try and do it on your own under the current circumstances with the Department of State, but we're happy to help with those, and those are options. Now, TN visas, and I've put with potential caveats, because the wording of the proclamation has been revised already, and it does have some amorphous regions in it that we kind of know should have been taken care of before it was perhaps issued. Currently, TN visas, and we have gotten confirmation from consulates indicating that those are exempted as well currently. And so we're quite happy about that as well. O visas, E3 visas, and there are a myriad of other E visas that can also be checked into for what purposes they will apply. Again, everyone was expecting this to disproportionately affect our F1s and our students. It did not. F1 visas, OPT and STEM OPT have escaped and hopefully will remain completely protected at this point. This also doesn't apply to anybody who uses ESTVA or is from a visa waiver program country. And so those are all things that you might want to check with a professional with, get some understanding of. But these are the visas that are currently non-immigrant in nature that would be issued by the Department of State and consulates worldwide still, and for which you can still submit applications. And so we'll go to the next slide to go in just a little further into this proclamation. So let's get into some of the mechanics of this. The suspension and limitation on entry pursuant to Section 2 of this proclamation shall apply only to any alien who, and it sounds wonderfully legal. What we want to do is break it down for you so that you can understand whether or not it actually applies to you or not. Is this an either or? Is this an all for one? How does this actually work? So the way this works is effectively all three have to apply. And what I have provided for you here is what the proclamation looked like on the day it was issued on the 22nd, and what it would have been effective as the 24th. There has been an amendment. It was yesterday. I have included that information for you, but in order for you to understand the differences about what has been issued so that people can get clarity, I want to be able to go through both. So as far as the suspension and limitation on entry is concerned, and again, it's on entry. It's not for individuals who are here in the United States who are either on an extension of status situation or even a change of status situation. This is predominantly for those who are applying for wholly new visas under those particular categories. So number one, again, you have to be outside of the United States on the effective date of the proclamation, which would have been June 24th in accordance with the proclamation. So if you're outside of the United States at that point, then prong one applies to you. Number two, in its original format, the second prong would have been you didn't have a non-immigrant visa that is valid on the effective date of the proclamation. Now, this caused a lot of consternation to attorneys when this first came out, because we were actually thinking about all of the non-immigrant visas that are out there and trying to understand how this fit into the role of the idea of this being for H1s, L1s, J1s. That has been revised. And the third prong, which is you do not have an official travel document other than a visa. And then they give you the examples, which would be a transportation letter, an appropriate boarding foil, or an advance parole document. Now, what are those things? Really? Does anybody even know? A transportation letter is in effect with only certain visas. It doesn't apply to H1s. It generally does not apply to certain areas of L1s. An appropriate boarding foil. A foil is in the event that potentially for most of the individuals that would be applied for green card holders, for EADs and things like that, where there may be a situation in which they have lost the document was destroyed, and they can get a foil from the consulate itself. An advance parole document. That document will be for people who have immigrant petition visas that are pending for them here in the United States. And that could be including some of the employment-based H-1Bs at this point. So again, if you have an advance parole document, this doesn't apply because you don't meet the third prong. So that's how this has to be dealt with, is prong by prong. So number one, if you're not outside the United States as you're hearing the sound of my voice right now, you can breathe. For number two, those of you that have a non-immigrant visa, and we'll go through that with the caveat for the amendment, we will explain what that means. And if you don't have an official travel document other than a visa, in other words, you don't have the accompanying documents that might be required, including a passport, then there might be an issue. And again, that goes with a valid passport, right? Not one that has either had an expiration or that might have been lost. Again, these are also subject to change and revision by the administration itself, which they have actually done as of yesterday, which takes me to yet another area of the presentation in the next slide. So again, we're going to go into the gears now and explain how it kind of works. So if you were outside of the United States on the date of the proclamation, you have to figure that out, first of all. And again, do not have a non-immigrant visa valid on the date of the proclamation. All three must apply pursuant to the plain language of the proclamation in order to be subject to the suspension and the limitation on entry. Now, the caveat for number two, on the prong, it has changed. The language has changed to include and be more specific and to include the specificity that most of us assumed would have been there, which was that if you don't have a non-immigrant visa in what would be the categories that were listed in subsection 2 of the proclamation, which are H1, H4, L1, L2, J1. They're specifically tying it to the fact if you do not have a non-immigrant visa in any one of those categories on June 24th, then the second prong will apply to you. Number three, you don't have an official travel document other than a visa. So we'll go through a little bit of the mechanics and trying to understand exactly how this works. If, let's say, and we've all heard of these situations and we're currently looking at them that are disproportionately affected, perhaps they're an H4 spouse that may have had to go overseas to see a family member, an older parent, a difficult situation with perhaps a funeral, or perhaps some other situation that comes up because life is life. At that point, if they left the country and they had a valid visa that they could re-enter on as of June 24th, They would still be allowed to travel and enter the United States. The problem comes into if you went outside and you needed a visa stamp to be renewed, if you needed a visa stamp to be issued to you, and because of the perfect storm of COVID-19 that closed the consulates back in March, you were not eligible or able to even get in, to get an interview, to be able to go ahead and, or even go to the window, to be stamped at that point. Now what do you do, right? And that is the actual problem, because what this is this is stage 2 of that storm, where they're saying, okay, well, it's really not our fault that COVID-19 took place. It's not our fault that you couldn't get in to get your visa stamp on time. And we've, to the credit of the majority of the media organizations, and a lot of people are coming out and giving these stories out so that people can understand the real impact of what this proclamation is doing to families. And we're not unaware of it. If there's no economic benefit that we can see from the standpoint of an H-1B individual coming in and potentially on fiscal year 2021 applications and petitions that were filed and can come in after October, we're looking at a situation where maybe they are only waiting 2 months till December because it's not stopping their stateside petition. I can understand, and anybody else can understand, the economic impact of that H-1B potentially being suspended under this proclamation. What doesn't make sense is H-4 spouses who were caught in this storm, or H-1Bs that were caught in the storm, or L-1s that were caught in this storm, and were not able to actually have access to consulates to get valid stamps and visas and to be able to re-enter the country timely, even though that they had everything with them and they applied, and they may have missed that window by a day or two when COVID-19 actually hit and everything was shut down. So again, we'll go back to those issues, and there is a legal argument with respect to the disproportionate effect on family members, and it's a real one. That doesn't serve an economic benefit. At some point, one of the things that is concerning to professionals like myself and individuals and businesses that employ H1s and L1s, like Google, Amazon, some of the biggest companies in the world, the concern now here is these individuals who are H1s that may have been stranded overseas, or their spouses and their children are stranded overseas, who might even be United States citizens at this point, who are young and cannot travel on their own. At some point, these individuals have built lives here. They have houses, they have cars, they have jobs. And at some point, if you don't allow them to come back into the country to be able to do their job or to be able to see their family members, the detriment is widespread. And the other problem is that the majority of our H1s and our L1s and these individuals are able to work remotely, wherever they are in the world. Their job is still going to be there at some point, whether they can re-enter the country or not. So at some point, you have to ask yourself as a professional and see the impact of the proclamation and ask, how is that truly helping with the unemployment rate here in the United States at some point? So apart from going through the mechanics of how this works in real life and how it's disproportionately affecting people's lives, we do have to go through the legal machinations of what this is. And so we'll go to the next slide to explain a little further. So, and this might be just what every H1 and L1 individual who are highly educated people that, they love going through this and parsing it with us, and they'll understand it as well. There are definite impact issues and nuances. And then the issue for the legal community and for those of us that are looking at the proclamation and looking at what seems to be, and you can see it at the bottom of my slide, that litigation on this may be inevitable. It most likely will be. And one of the reasons why is because of the way that a proclamation or an executive order is parsed. Majority of the time, it is a plain language reading that we're looking at. And what does that mean? That means the letter of the law. It means the way we actually look at the language to see how it would be enacted. How should it work? So, in other words, Those who are already in possession of a valid visa prior to June 24th will be allowed to enter the United States, even if they're traveling abroad for future or already outside of the United States. Now, there's a caveat to that. You're going to ask, and there's going to be a situation in which there's an H-1B who is stamped, who was overseas, who cannot travel currently. And they're going to ask, well, I have a valid passport, I've got a valid I-797, I have a valid I-94, and I have a visa stamp that is still current. Will I be allowed to travel and enter the United States? Well, ostensibly, under the plain letter of the law reading of this proclamation, the answer would be yes. But then there aren't too many lawyers these days that will say yes without a disclaimer under the administration's current policy, initiatives, and the way they are interpreted at the border. Because again, this deals with CPB, which is Customs, Border, and Patrol, and it will depend on port of entry. We are looking and waiting for information, examples, guidance, which usually comes in the wake of one of these, although we don't have it yet. So the answer is to all of those individuals that are worrying, we are also worried about it, but our recommendation to you is stop, wait, listen, and let's get some guidance for you before we jump onto a plane. Those who were in the United States on June 24, 2020, as well as anyone who held a valid visa on that date should be exempt, and you can see I've written should be, under the plain language of the law, exempt from the immigration proclamation, whether they were inside or outside of the United States. Now, everyone's going to jump at that. What does that mean? Even if I'm outside of the United States, will that work? And again, it goes back to that understanding, that nuanced reading. Are we looking at a plain language reading? Well, we thought we were until yesterday, when they set out another amendment because of the ambiguous nature of the language that's involved. And that's another reason why we believe that litigation will most likely be inevitable on this. So as a caring lawyer, as a professional who's done this for quite some time, and I think that the majority of my colleagues agree with this as well, and those who are scholars in this area, caution is advised completely with respect to travel. And part of it is due to the interpretation of the Department of State's so they've put out a frequently asked questions section. It was very interesting because that was given out ostensibly the day after the proclamation was issued. And it was very interesting because we as legal professionals were looking at it as potential non-adherence to the plain language of the law, which in legal terms means the Department of State put something out there that actually wasn't legally in the proclamation, and it looked like they might be in defiance of it or perhaps in complete opposition to it. And it turned out that the amendment that was made yesterday was in compliance with the Department of State, and what it was is they just didn't write it very well. It's very difficult to say that, but the truth is that it was a badly worded proclamation. And there we have it. I think pretty much all the immigration attorneys would probably agree with me on that one. So we are looking at potential amendments. We're also looking at potential clarification. Attorneys like myself, through the American Immigration Lawyers Association, and in general, we're checking in with CPB, which is the Customs and Border Patrol. We're checking in with consulates around the world, and we're trying to get clarity and understanding about specific instances and situations that we know would be affecting our clients and people who have these visas. I do want to make one more note, which is that under the H visas, the H-1B1 visas, the Chilean visas, are not affected by this. And we have received notification from consulates that those are not touched by this. So if you have that visa, you are currently safe. And again, if you look at the infographic on my screen, I'd like to make sure that your eyes go to the bottom left corner where it says caution. I don't know how to express it any more than I can here. Please be careful. Please check in with a competent attorney. Whether it's me or somebody else, it does not matter. But the reality is that right now, this proclamation is so new and the plain language of the law has not been interpreted completely, that before you go on the internet, research on your own, listen to other things and other cases and people that are actually trying to get to the consulates right now. Please, 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 please check in with someone who is in the know. And so that'll take us to our next slide. So exemptions from the proclamation. Who is still allowed to come into the United States under the present circumstances and the whirlwind of proclamations and executive orders that have come through? Well, any lawful permanent resident of the United States is still welcome here. Any alien who is the spouse or child of a United States citizen is still eligible. Any alien seeking to enter the United States for the purposes of temporary labor or services that are essential to the United States food supply chain. This is very important, and it is COVID-19 specific. And those, again, because of the language that is broad in nature, it's probably not a good idea to interpret it on your own. You would want to check with an attorney if you are actually in any one of those particular situations. Again, any alien whose entry would be in the national interest as determined by the Secretary of State, the Secretary of Homeland Security, or their respective designees. This is a caveat that is usually put in, and again, national security interests are one of those that go straight along with the actual authority under which this proclamation is issued. So we're going to delve into some of what are those exemptions, what exactly does it mean under national security, and are there distinctions underneath that? Well, those are going to be in my next slide, and we'll go to those immediately so that we don't have to hold anybody in suspense. So what exactly is a national interest exception, right? Because is a lawyer that knows some part of immigration law, are they a national interest exception? No, there's a breakdown in all of these categories. And to be able to know whether it affects your H1, your L1, or your J1 for that matter, we need to go into the issues and break them down as per the proclamation currently, which is national security. A national interest or national security interest exemption will be specifically for purposes of defense, law enforcement, diplomacy, and the catch-all phrase, national security of the United States. What exactly does that entail? Let's say you're a computer specialist who actually works for a company, and we won't use the actual word, we'll use a different word like Diamond Stone, or somebody else who's actually has contracts with the United States government to be able to deal with defense and national security and assist with that. Are you considered someone that might be in that national interest carve out? Well, you might well be, but that decision and that information and the evidence thereof, you would want to check with an attorney. It's not something you can do on your own. It's not something, there's no mechanism and procedure currently in place for us to tell you or even explain how to go to a consulate currently and what evidence would be required and accepted by a DOS consular officer. And he would sit across the desk from you, or he or she would sit across from the desk from you and say, yes, I absolutely believe that your job is in the national security interests of the United States. But we will find out. And I believe that the majority of legal professionals, we understand exactly, to some extent, what the Department of State in previous administrations and under previous precedent has seen as national security interest. And I believe that those are the things that will be vetted through this process between now and December 31st, unless we see a rescission of this proclamation or a further amendment, or if we see an injunction by a court of law with regard to portions or all of the proclamation. The second carve-out is for medical care to individuals who have contracted COVID-19 and are currently hospitalized. That brings to mind every healthcare service professional on the planet. That literally is the carve-out exception. If you are somebody who has knowledge of how to deal with respirators, you're wanted and needed. If you are someone who is working for a hospital currently and you are a medical care professional, or you are within that purview for H1 and L1 purposes, you need to get on the phone with a lawyer at some point. And if you are not outside of the United States and you don't have a valid visa stamp and you don't have a travel document, you need to go ahead and speak with someone to see if you actually might qualify for that exemption. Again, medical research at United States facilities to help the United States combat COVID-19. And why not? We need those individuals desperately. So how does medical research work? Well, let's see. We're asking ourselves as professionals, and we're trying to give out information to individuals like people that are watching this webinar to find out whether or not, if you're a computer individual or an engineer that works in this area, and let's say your work is vital to being able to allow that medical research to take place at a given facility here in the United States, does that mean that you're eligible for this exception? You very well, you might be. And there are ways to vet all of that and to take a look at it to see whether it's a tenuous connection or it's going to be one that's a little bit closer to what the context of this particular proclamation exception was. Again, last one, anybody that would be necessary to facilitate the immediate and continued economic recovery of the United States. Well, there's an argument to be made intellectually, academically, and legally that would be everybody. But at some point, this is going to be a case by case. Just interpret that star as a case by case situation. If it is a company that is, again, vital to the U.S. economy, if it's affiliated with the food supply chain, or perhaps other areas of the supply need in the United States, you very well might be eligible for that. This hasn't been vetted yet. It's so new that I've seen people trying to interpret the proclamation the day it came out, and the first thing that the majority of some of us who have been in this a little bit longer said, why don't we wait? Because we know that some of the language is going to be tweaked. We know that some of this is going to be looked at again. There's currently no guidance, no definitive guidance that has been drawn out for each one of these exceptions. However, those individuals who have some experience with it, and again, precedent, understanding of what the Department of State would be looking at, we can assist you with that to determine whether or not you're necessary to facilitate the immediate and continued economic recovery of the United States. And so let's go to the next slide, and I will be able to help you understand a little further what we have. So this is an interesting one, and I've saved it kind of for last. We have the Canadian quandary. How does the proclamation affect our H and L visa holders to the north? First of all, we value you, just as we do all H1s and all L1s. The reality is that because of the intricacies of the Immigration and Nationality Act and the way visas are treated from different countries, and with respect to certain caveats that are already there in the system, which is one of the reasons why a lot of us, when we saw the proclamation, were concerned of its overly broad nature. It immediately asks the questions, begs the questions. What about this? What about that situation? And I'm sure that our viewers are thinking the exact same thing. So there is a proposed argument to exclusion from the proclamation pursuant to what would be 3C, asserting that since Canadian H-1B and L-1s are they're technically exempt. They're what we call ostensibly visa exempt. They don't necessarily need to have a visa to be able to enter the United States on that H-1 and that L-1, that they should be allowed to travel. We have received some information from consulates that indicate such, and that and at the border, from CPB as well, that they're going to allow them to travel currently. Now, that's not written in stone. It's not written in blood either. So again, best to check with a professional before you head to the border with it. The issue will be determined, I think, and there's one caveat there that I want to go over really specifically, which is that if you're looking at that Form I-797C approval notice, that should be deemed sufficient pursuant to the section to be able to allow you to come into the United States if you're a Canadian H and L. Why is that important? It's really important because at some point, even though you may be visa exempt, that 797 will be treated differently at the border. And you need to be able to have an understanding of how that actually works if you are a Canadian national who has an H or an L visa. And at that point, you would want to be able to speak with an attorney to see what are the other options, because remember, a TN visa is still also an option, and that is fully exempted from the proclamation as well. So I hope this gives a little bit of clarity as far as that goes. And we'll go to the next one. But I do want everyone to understand. We can go to the next slide, and it shouldn't be an issue. And again, I want people to understand at this point that there are a lot of questions out there. There's a lot of questions on the minds of professionals like myself. I've tried to vet as many of the issues here under the proclamation that we can currently. I will say this. It seems very clear that there will be litigation at some point, and it would behoove a lot of individuals who are affected by this to perhaps get in touch with attorneys to find out, because there are nonprofit organizations, there are other organizations, including the American Immigration Lawyers Association, that are going to be gathering this data. They're going to be gathering information, and it will be most ostensibly for purposes of litigation on behalf of individuals. And again, that's not on an individual basis through a law office. That's through organizations that will be assisting in this. And so, again, just like everything else, it seems with this administration, a lot of the executive orders will be vetted in the courts to some extent. Do we expect any additional clarification? Do we expect some guidance to be coming out? Well, we're definitely hoping for it. We have thought about, and some of us who live, eat, breathe, and sleep this stuff, we think about it day and night from the day it's been issued out. And I can tell you that it weighs heavily on me with my H1 clients and the candidates. I've been doing this for over 20 some odd years, and a lot of these people are family to me. They've been here a long time. A lot of them are visa retrogressed. They're on their third, fifth, fourth extensions. This is scary. It truly is for them. And I think that it doesn't escape us how truly scary this is. No child, no spouse, no family should be separated for this purpose. They should not. And I would hope that the administration will look at that. I hope that the Department of State will look at that. I know that the attorneys are looking at it. And I know that we are looking very seriously at helping our H-1B employees breathe a sigh of relief to some extent, to understand how this is going to affect them. For those of my individuals that might be H-1B fiscal year 2021, who are overseas currently, if you have a stateside petition, and believe it or not, today is coincidentally the actual date for the end of CAP filing. All CAP filing should have been completed by today, as far as we know. And the majority of these people will be adjudicated here in the United States. If you get approved, does that mean you cannot enter? It means currently under this proclamation, you may not be able to enter unless you qualify for one of the exemptions until December 31st, 2020 or beyond. However, that does not stop the adjudication of your petition stateside, and that's important to remember. We do believe that employers and businesses are going to try and, in response to this, have to retool. They're going to have to look at offshoring. They're going to have to look at other options. And it is my understanding that on bank, they have all written, and a lot of them are talking to the administration directly. And so we do not know if we will see some more revisions, but we can always hope. And the rest of us will be here hoping to help the rest of you.
Thank you so much, Anjali. This was an incredible presentation. And I know that sort of in a day and age where we're inundated with a lot of information that's out there and a lot of interpretations, it was really helpful to hear it from you and with your expertise in this area. So I know we just have about 10 minutes left, and we have a question that I can pose. So a question that's come in is from someone who is sharing that they have an H-1B visa stamped on their passport, but they've currently lost their job, their employment, and they're applying for new jobs. And so when they get a new job, will they be able to use their current visa stamp along with a new I-797 form from a different employer?
So I'll have to say this with a caveat, because these webinars are not for the purpose of providing direct legal advice or consultation, because without documents in front of me, I cannot provide specific information. I can only do hypotheticals, and I can try to assist from there. And we've had individuals who have been impacted, and I can try to express it in the most generic way possible. If you are here in the United States and you are an H-1B current visa holder, and you have been working and perhaps either, and again, this goes back to the webinar I did earlier, which deals with layoffs, furloughs, and terminations, all being very different categories, because I do employment law as well, and those have nuances. So it depends is the answer as to whether it is a layoff, termination, or a potential situation with furlough. So this particular individual would want to look at the options that are available in terms of time period to be able to switch over or change to a different employer. If they are here in the United States and they are changing to another employer, the petition will be sent in. If it is sent in correctly, it will be sent in as an I-129 petition for an extension of status while here in the United States with a change of employer. None of those items are in the proclamation. So, without being able to give specific advice, the answer would be, if it is being filed correctly, and it's an I-129 petition with an extension of current status where they can prove their current status with a change of employer, they would be issued a form I-79C with appropriate information, including an I-94 on it. And so hopefully that will help and assist that person. I will also recommend that they check specifically with a seasoned attorney, whether it's me or somebody else. And so I'll take another question if there is one.
Definitely. There are lots of questions, so you might need to narrow down a little bit. So another question that I'm seeing here is that someone has received an RFE for their STEM extension OPT. Is it true that there has been flexibility around that?
So they might want to look at my previous webinar in which I addressed one of those issues. I hope it's still up on the SEVA site, and if it isn't, they can email me or go through one of the organizations to ask again. The answer would be, please refer back to that information that was provided, because it specifically spoke to issues around flexibility. Again, I cannot provide legal advice on an RFE that I have not seen in front of me and don't have the documentation for. No lawyer could do that. However, I do think that they should, and everything is case dependent. I know that the viewers want immediate answers. Trust me, the day the proclamation came out, I wanted to be able to have a direct line to the administration as well, and answer all of our questions. And I was looking through a Rolodex to see if I knew any former DOS officers that I could, I don't know, talk to. But the reality is that these are nuanced, and they have to be looked at properly with a legal professional who has worked with those issues before, because this is an unprecedented time for these individuals. STEM OPT, as you saw in my current slide presentation and under the information, is exempt from all of the proclamations currently under this caveat. So if you've gotten a request for evidence, it means that they're asking for something specific. It would be best to do this under the guidance of a lawyer and then go from there, so that you can understand whether that flexibility applies to you, does not apply to you, or does not exist. And that's the best answer I can give on a live stream without a document in front of me.
Thank you. I know it's difficult, but I'm sure everyone listening in really appreciates it. And all of the previous webinars are available on the 𝐀𝐧𝐣𝐚 International USA page, 𝐀𝐧𝐣𝐚 USA YouTube channel. So please feel free to reach out or check out the previous links as well. Another question that I'm seeing is someone is asking if you could just clarify or share a little bit more about the impact of a travel ban for eligible non-immigrants with a valid visa stamp who are planning to enter the US.
Okay, so that goes back to, I think it was like slide 3, if I remember correctly, and God help me. Lawyers will always go back and refer to things. The answer would be, again, and I'm going to go back to it, is that little caution sign that I put out there. And I think I made it pretty clear on the slide that under the current guidance, which we actually don't have, these are interpretations that we as legal professionals are completing and making sure are being done. And oh, I see they're trying to go back to it. That's wonderful. I don't think it was that one. It might have been the one prior to that. We'll take a look and see so that I can help you here. So again, I think I'm so sorry. Perhaps it's the one after that one and the one after that one. This is the letter of the law here. It's the one with the little caution stamp on it. It's in the bottom left corner, if that helps. We'll get to it. Hang on, there it is. So I think I made it clear here where caution is advised completely with respect to travel. And it did say very clearly that those who already possess a valid visa stamp and a Form I-797, who may be overseas, ostensibly whether they were inside or outside of the United States, as you see here on this slide, would be exempt from the immigration proclamation, and they should be. And I think I made it very clear in the presentation that the question is should be. We are looking for clarification before we allow clients and individuals, and we advise them that you are in the clear. The best thing to do is to get in touch with an attorney, show them your documents, and remember, you're not just a document. You have a history. You've probably been here for, maybe you were an F1 student who came here and studied, and you've been on H1 for a while. We need to know your story as well so that we can understand what area you're working in, whether or not this actually applies to you or not. What was your last visa stamp? When was your last change of employer if you're an H1? All of those things matter. You're not just a document. You are your whole story. And that's why we say it's case specific. I can't tell you how many times I've heard, well, I have a friend that, oh, my cousin did it this way. Yes, that's wonderful. I've had twin brothers who went to the same school, get H1s in the same company with the same title and position. And I can tell you right now that their cases were not identical, even though their DNA was. And so the answer is you really do need to check. And yes, right now, under the proclamation, as it's worded, we would like to say that those individuals could travel or should be able to travel. Question becomes, can you wait a little while for some clarity to come out so that we can also assist? Because at some point, this is so new, it hasn't been vetted in reality yet. And so we want to make sure that there's no more amendments coming out in the coming days and weeks. So I hope that'll help that individual as well. And we're happy to look at documents.
Thank you. It looks like, I think we're just about out of time. But anyone who has asked a question anywhere on the live stream, we'll try our best to get to all the questions. And anytime, please feel free to reach out to us for any support. If you or anyone you know has any specific concerns related to the topics that were covered today for 𝐀𝐧𝐣𝐚, or even otherwise, if you're seeking any support related to COVID-19, please do not hesitate to reach out to us on the helpline. I just wanted to again state my and express my gratitude, Anjali-ji. I think the topic today is one that brings a lot of stress to many people. There is a lot of complex language and history, and I really appreciate you connecting it back to the person, because at the end of the day, we're more than just a visa stamp, more than just a letter and a number.
Yes.
We're people who are living in this country and want to contribute to this country in any way, and I really appreciate you sort of bringing it to a really personal level.
Thank you. It is personal.
It really is. And I hope that everyone who tuned in today was able to connect and get some of their questions answered.
I was just going to say really quickly, I didn't mean to interrupt you at all. I just wanted to say that I'm happy to do a follow-up on this. As soon as we get some additional guidance, I will be posting some information, not just on my LinkedIn as well, but on the website and other places. But I will not have any problem providing guidance and updates as they come in, including with litigation. If that and again, I want to stress this just so that those individuals know. Please reach out. And if you are somebody that is affected, there are a lot of organizations that folks like me know are going to be gathering data and gathering your lives and your cases and your information to present and make sure that there's a challenge where it's needed. And so don't hesitate. I know it's a fearful time, but we're here. A lot of us are here to try to support. H1s are dear to my heart. I've been doing them for a long time, and L1s, and my heart goes out. I can't tell you how many stories I personally have of people that have called me and I've tried to assist. My heart goes out to all of them, and we will get through this. I promise.
Thank you. I really appreciate it. It's great to have these resources and community here to support us in this time of need. And I think many of us may be following the SEVA pages or any of the connected organizations today, and we have a lot of upcoming webinars or ways that you can support the local community. One that I wanted to mention today that might be of interest for people of all ages, a topic on cybersecurity. We have an excited high schooler who will be conducting this webinar, and he'll be able to cover some of the vulnerabilities that we're exposed to while working in an online space. And so I hope that those who are interested can tune in tomorrow at 9 o'clock Eastern. And again, please do not hesitate to reach out if you or anyone you know has any concerns about the topics mentioned today, or if SEVA International or any of our connected organizations can support you during this time. Thank you so much, everyone, and thank you, Anjali-ji.
Thank you guys for giving me the opportunity. I appreciate it, and good luck to all.
Thank you.